So welcome to another edition of EJIL Live, and I have with me Professor Merris Amos from Queen Mary College, London University, and we are featuring your article which will come out in the next issue of EJIL, The Value of the European Court of Human Rights to the United Kingdom. Welcome.
Thank you for inviting me.
So before we get into your actual arguments, I mean, it is quite shocking that in addition to Brexit, there's been talk from the highest quarters, from government ministers, suggesting that the United Kingdom should also withdraw from the European Convention on Human Rights. And no matter how they try to camouflage it, it's not a functional argument. It's also a sort of visceral, reactive argument. So maybe before we go into the actual arguments you made about the value, try and explain to us this negativity in the United Kingdom.
Well, the negativity has been very bound up with an anti-European sentiment generally, and there's been a lot of confusion between antagonism towards the Council of Europe and antagonism towards the EU. So in the run-up to the referendum, I think the two were conflated by the Conservative Party as almost being so much confusion between both, that the negativity towards the European Court and human rights, they were perceived as the same thing, the EU and the Council of Europe. And essentially, the Conservative Party started its earnest campaign against the European Convention, I think, to be very cynical about it, as a way of winning votes and distinguishing themselves from other political parties. And that happened in earnest in 2014. But surprisingly, or perhaps not surprisingly, once the vote for Brexit happened, the antagonism, or the public antagonism from the very high political leaders such as the Prime Minister towards the European Court of Human Rights has lessened a little. And
getting cold feet.
Yeah, well, it's thought, wow, Brexit, the vote for Brexit was really quite unexpected to those campaigning for it.
So was the sort of anti-Strasbourg talk just vote catching and not really serious, and now they're worried that they might actually...
Well, there's a different division within the party of government over the Council of Europe as opposed to the European Union. So there are conservative politicians who are opposed to the European Union membership, who are actually very strong supporters of the Council of Europe, and one of them is the Foreign Secretary, Boris Johnson. So those lines divide slightly differently.
So Boris Johnson is, of course, a Brexiteer, but he would like to remain part of the convention system.
That's right. He's a very strong supporter of the Council of Europe, as opposed to the Prime Minister, who is... She was the one who made the speech prior to Brexit saying we should stay within the European Union, but we must leave the Council of Europe. Yes.
Do you have any indication, I know one can only pick up signals of the attitude of the British judiciary to the convention in Strasbourg?
The higher judiciary and the Supreme Court, they're almost all very positive towards the convention. There's a couple that often express some concerns about the quality of the jurisprudence, and they might find it confusing, and they might express that in a judgment. And we have a few examples of decisions where our highest court has actually said, we don't think this thread of jurisprudence is actually correct. It's usually Article 6 cases, fair trial cases, where the British judiciary are very confident talking about fair trial, and they will send it back. They will give their own interpretations of jurisprudence, and it will eventually make its way back to the court.
Because I've seen this with other judiciaries, because fair trial hits at home,
Yeah.
The judiciary are responsible for fair trials, whereas other condemnations, it's usually the legislature or the executive branch. So
Yeah, they feel very confident with fair trial.
and also very jealous about that.
Yeah, yes.
To decide what is a fair trial.
Well, the British judges in common law, they feel that some of them feel like they've invented fair trial, and so they must be the greatest guardians, and they'll tell the European Court what to do. But there's not a similar confidence in respect of other convention rights. So I think with privacy, our judges have felt their way for the last 17 years, and they're gradually coming to grips and gaining more confidence.
In your article, you eschew the notion of legitimacy and other criteria for evaluating the European Convention of Human Rights, and you present two different criteria. So maybe you can explain that to our viewers.
Yes, so I'm quite used to speaking at events in defense of the European Court of Human Rights, and I found talking about or asserting that the court was legitimate was very difficult, and it didn't really capture the imagination of the audience. And so I thought it was important to look for something which would provide more answers, essentially, in the debate that we're having in the United Kingdom. And so the British government remains committed to human rights protection and remains committed to protecting human rights through law. So we have our Human Rights Act.
Through law and through judges.
Yes, through courts, yes. We haven't reached a position where Parliament must have the final say. We already have that position in the Human Rights Act, where we don't have a strike-down power for our judiciary. We have something called a Declaration of Incompatibility, which is almost always acted upon by Parliament, except for prisoner voting, which is an outstanding declaration of incompatibility since 2007. So we do already have a system where the power really resides with Parliament at the end of the day. And so I thought this value, what is the value of an extra layer of human rights law protection provided by the Convention and the Court to a government's objective protecting human rights through law? And I knew there was literature, quite a lot of literature, looking, not using the language of value, but looking at similar ideas, saying that treaties are of great benefit to...
So the argument would be, if I understood it correctly, that if you want protection of human rights by law and by judges, here are some reasons why membership of the European Convention on Human Rights can actually give added value.
That's right, added value to that objective.
For an objective on which there is consensus.
If you're serious about this objective, we can have this additional help in achieving.
So then you define the sort of value you have 2 or 3 ways of...
Yeah, well, I thought it was best to express it as 3 different levels, because that's what I was seeing in the literature, not all together. So there's value at the individual level. It allows individuals to bring an application to the court without relying on anyone else to do that on their behalf. It's up to the individual. There's value at the global level, which was harking back to the origins of the convention system to resolve these pressing global problems, maintenance of peace, to act as an early warning mechanism, problems emerging in contracting state, to set minimum standards. And there's also value at the national level, which is what most scholars will write about. And so I thought there was so much literature on value at the national level that I split it into a static value, which it acts as a disincentive to breach the convention. It provides accountability and redress in the case of individuals, but it might provide no wider change. It also preserves the status quo, which is something that Karen Alter has written about, this function of a court such as the European Court of Human Rights, confirming perhaps quite a conservative position on the part of a contracting state. So we have an example in the UK with political advertising. We have a broadcast ban, radio and television, on political advertising. And for many years it's been a campaign subject in the UK. People are distressed about this. They want that kind of advertising. And the litigation went through the UK courts and they said, no, it's not incompatible with freedom of expression, and that was eventually confirmed by the European Court. So it's like, preserve that status quo, there's no progress on that issue.
Well, if you see what happens in the United States, where basically money has become such a huge factor in politics. So let's just focus first on the value to the individual, and maybe be a little bit more specific on that. What is the value to the individual in the United Kingdom of membership of the Convention? Reading your article, it seems to be the premise that enhanced protection of the individual is an unqualified good, and that membership of the Convention can ensure, if not only the maintenance of the status quo, but you actually say the Convention develops, etc., so it can give enhanced protection to the individual. Mm-hmm. And my pushback is as follows, from two opposite directions. I've always maintained that it's conceptually wrong to think, when one thinks of human rights, of higher level of protection or lower level of protection. Because I always think of human rights as a balance between a collective good and an individual liberty. So enhanced protection to the individual is often at the expense of a collective good, of the ability of the collectivity to assert a public good. The more protection of private property you have, the less parks can be made available to the public by, say, taking over some private land and making it for public use. Mm-hmm. So I'm not sure that it's an unqualified good to say, especially when you say the Convention develops and more rights are given, that is a winning argument, because that it almost begs the question, if one disturbs the balance between a collective good and a private right, others might say it's a net loss to society. Mm-hmm. And coming at it from the opposite direction, although it's not meant to be such, although formally the European Convention is meant to be the safety net and member states can, quote, go beyond it, so to speak, but increasingly it sets the standard for Europe. Mm-hmm. So when the court says, the European Court in Strasbourg says it's kosher, it becomes kosher for everybody. Mm. So when they confirm that there's no violation of human rights, it might be a loss, because then it becomes more difficult to argue before a domestic court, you should protect this as a human rights, because immediately they say, well, even Strasbourg said it's okay.
That's right.
So how do you answer those two pushbacks?
Well, in answer to the first question, I think it depends very much on the right you're talking about, because as you know, some of them are absolute rights and some of them are qualified rights, and so, or
I don't believe that
rights.
There's any absolute.
Oh, you don't believe there's any absolute rights? No, this is
not even the right to life.
Not even torture.
Not even the right to life.
No.
Torture is absolute.
Mm-hmm. Okay, so there you go. There's an absolute right. Yeah, we have a lot of litigation on in the UK.
I know, but how to define torture? That goes to my second critique.
Yeah,
they might define it in a way that we would say it doesn't go far enough, and then it establishes practices that we would actually like to eliminate.
Mm-hmm. Well, I agree with you that it is quite dangerous to allow an international court to set the benchmark, because often they're trying, it's 47 contracting states. The European Court is quite fond of finding consensus as a way of making its decisions. And so sometimes you're winding up with not the best solution, most progressive solution, but the one that most states will accept. I think states
and most states ranging from Russia to Sweden.
Mm-hmm. I think most states not most states, I think some states may well have more imaginative, and I know they do, and more progressive interpretations of human rights. So, for example, in the UK, there's been a lot more gains in relation to equality and sexual orientation discrimination than have emanated from the European Court of Human Rights. We've gone beyond and made progress in that instance that hasn't been driven by the European Court of Human Rights. So it's not exclusive that it will be the driver of change, but it can be the driver of change in instances where perhaps that issue is not as...
Don't get me wrong, I don't want you or anybody watching this to think that in any manner or shape I support the United Kingdom withdrawal from the Convention, but I do think that there's more nuance to the argument you make there. You kind of say there's a value because it enhances protection of human rights, and I just, as I said, it's...
But I think also when I applied this framework to the experience of the UK, because now in the UK we have relatively strong human rights protection with the Human Rights Act, which replicates the Convention in national law. And if you look at the record of the UK before the court, at the moment, it's actually very, very good. And a lot of these gains and progress in relation to the protection of human rights is happening at the national level, utilising the Human Rights Act. And the cases that are going to the European Court are either very difficult questions of interpretation of facts and their application to an absolute or a limited right. So Article 3 in the context of deportation, immigration detention, and Article 5. Or they're very progressive arguments which perhaps haven't been realised in any other national system. So the De Silva case recently, where it was argued that it was a violation of Article 2 for a prosecution not to be brought by the Director of Public Prosecutions. And that was rejected at the national level, was also rejected by the court.
So tell us about now the so-called global argument.
So the global argument is a way to say that this is probably the most traditional argument, is that the court is there to solve these pressing global problems, or not perhaps solve, to go some way towards finding a resolution, setting a minimum standard, making sure that there's early warning systems, something going on in a contracting state. But the global value, so the UK being part of this system and benefiting from that, some critics of the court in the UK say, well, we don't really need that. That system can carry on, similar to the European Union, can carry on without us. But so I was interested in thinking, well, is that correct? Is that something the UK wants to miss out on? And essentially it boils down to, well, if the European Court of Human Rights is the primary shaper of human rights norms in the world, which it is, the UK outside of the system is not going to really have much of a say in shaping those norms anymore. And so you can look at some of the jurisprudence of the court, like some recent examples. There's a case concerning policing of demonstrations, the Austin case, where the British Supreme Court had an enormous influence in the judgment of the European Court eventually reached, which has implications for all contracting states.
Probably the system, I think you're right on that, but I think the way I see the real danger is not that Britain would lose influence or that somehow human rights would lose out, but that there would be contagion. In other words, if Britain left and, the mother of democracy and all that, it would be an invitation for other member states of the Convention to leave. And that would really have implications far more serious than the mere withdrawal of the United Kingdom from the Convention. So there, one has to appeal, as you write, to some kind of global responsibility. And the last one was the national interest, was it not?
The national, value at the national level, which is probably the most important, this notion that it's a disincentive. So it's after 17 years of our national legislation, the Human Rights Act, it's kind of ingrained in our...
It's been 17 years.
17 years, yes.
It's like yesterday to me.
It seems like yesterday to me as well, yes. I was there when I was working in Parliament, when it went through the Houses of Parliament, so it's been almost 20 years for me. But yes, so it's embedded in policy making to some extent, especially in the legislature. And so there's a concern now when bills are going through Parliament that they're human rights compliant, and not only compliant with national jurisprudence, but compliant with jurisprudence of the European Court as well. So there's that disincentive to act incompatibly. There's also redress for people. So now, as I'm seeing in the record of the UK before the court, there's a lot of individual claims going through, which just affect that person, fact specific. And there's also this confirmation, the status quo, maintaining the status quo, as we were talking about earlier. There's also dynamic change as well, which a judgment of the court can achieve, changing things in the UK that have been resistant to change, or throwing up something completely new that wasn't thought of before. So I think that the best example of that...
Not to challenge that, but to just probe a little bit. I mean, that might still continue. I mean...
If the UK were to leave the convention system?
Yes, I mean, the Human Rights Act does replicate the convention. The judges will automatically look at the interpretation given by the court.
Provided the Human Rights Act doesn't change.
And you think there's a risk, there would be a risk of that?
Yes, that's how the change would come. It would be a UK Bill of Rights, which would replace the Human Rights Act.
But would they actually change the substantive provisions?
Yes.
They would?
Yes. Well, there was talk of that in 2014 when they published their consultation paper.
Maybe tell our viewers why the United Kingdom is so het up about prisoners' right to vote.
Yes.
I mean, that seems to have been the case that ignited
yes, it drives everything. It drives everything because it's...
what's the sensitivity there?
I'm not sure if there's a huge sensitivity. Actually, it's an issue which captures the public imagination very easily. And it is very easy to say to a crowd of people, I don't think prisoners, this is not my perspective, but to say that prisoners shouldn't have the vote, and how dare an international court tell us that? It's so straightforward. It's so easy to encapsulate.
The record of British prisons is not that great.
Well,
so
you know what?
A
couple of years ago, under Conservative government, when...
it's a kind of punishing society. Not only should they be incarcerated, but...
Well, Michael Gove, when he was Lord Chancellor, he actually came very close. They were very close a couple of years ago to giving prisoners some form of vote, some limited ability, maybe
the same big Brexiteer, Michael Gove.
Yeah, Michael Gove, it was very close. It was very close. There was a very good report from the Joint Committee. There was a committee set up in Parliament. They recommended a solution. And then it all went out the window with the change in ministerial staff and the new Prime Minister. And we're a long way off now. We're a long way off again.
But what is it in popular imagination, in popular psyche, that makes the right to vote such a lightning rod?
It's more about being a prisoner, and it's about people who, perceive, oh, prisoner, you've committed some kind of crime, and you're incarcerated, and you shouldn't have anything, you shouldn't have any rights, and you especially shouldn't have a right to vote. And that's just something that's you have to understand. It really speaks to a lot of people, and they find that that's a very argument that they can agree with.
And somehow it ties in with sovereignty, doesn't it?
Yeah, sovereignty.
We should have the right to decide rather than we really want prisoners not to have votes.
It captures everything. It is how dare an international court, how dare a European court tell us what to do on this, because there's a judgment of the Court of Justice as well on voting in European elections, but went the opposite direction, as I remember. And yes, it was at the forefront of their arguments, even though the judgment, I think, was delivered in 2005. So how many years can they keep that argument going? 12 years.
So I want to say also to our viewers, and to thank you on behalf of the editors, I think the importance of your piece is not only in making, in this very specific way, the actual added value rather than the legitimacy of British membership of the European Convention of Human Rights, but it makes us think about the convention system and what is good, what could be. There's nothing that's so good that cannot be better. So it sort of focuses the mind on something that we've taken for granted.
That's right.
just now to move back to politics, it's not going to happen, is it?
Well, Brexit's diverted attention at the moment and probably for some time to come. I don't think the British public are ready for another extraction from a European institution at the moment. I think they're tired of all of this. And even though the policy of the present government is to revisit this question once Brexit is complete, I think there'll be a few more elections before this is back on the agenda. And my feeling is now, unfortunately, or fortunately, I'm not really sure, Brexit has saved the convention. Because it would have been one or the other, which went after the 23rd of June. And if there wasn't the vote for Brexit, we would have probably left the convention system by now. Because something had to be sacrificed to the Eurosceptic monster.
That's a devil's deal. Well, I suppose we should thank God for small mercies, because we are sitting here at the European University Institute, which has provided so many teachers in various British universities, graduates, not only UK graduates.
Yes, many of my colleagues, yes.
And at least there's no sign that the United Kingdom is thinking about withdrawing from the convention establishing the European University Institute. So at least we should smile about that. I want to thank you, Merris Amos, very much, and thank our viewers for watching. Thank you all very much.
Thank you.